Mr. Gomez, how would you respond to that and the characterization that there is a working relationship with the boards and keeping them in the loop and identifying the challenges of moving forward in some type of timetable?
Well, I would answer that in the current model that the department is using with our performance targets and our performance measures, I mean, we do look, and I think Assemblywoman Baker mentioned the issue of looking at case types and case complexity, because if you look at and follow that, there's going to be higher time cycle for very complex cases versus the more routine cases, if you will. So to the extent you're going to build a performance measure versus case aging, but a performance measure and targets, there has to be a recognition of what the complexity model would look like. And I think that we can talk about intake, we can talk about intake and investigation, but when it goes over to the adjudication side, that is where maybe there needs to be a carryover of what that would look like in terms of developing those targets. And that's what Director Kadani and I were talking about earlier, is that's why we're going to go back and look at our performance targets and our performance measures, because we do have the track record. We do have, I think, the data to support, is there a difference between the case complexity of the complaints themselves, and how do they proceed? Are they closed at the board level? Are they closed because there's insufficient evidence? Or do they go forward for an investigation where the formal investigation shows that there probably is no there, versus those that go over to the AG's office or a service request from the board to draft whatever a case is? We have to look at the case construction and what that means.
Thank you. So there is hopefully a willingness to sit down and maybe look at the ability or the possibility of moving forward with looking at the different types of cases and coming up with some type of standard and approach that would work. So thank you very much. And thank you. Can you have questions at all? Well, thank you, Senator Wojciechowski. Yes, Mr. Morzini.
Thank you. Good afternoon. Zach Morzini, Director of the Office of Administrative Hearings. Thank you, Chair and members, for inviting the Office of Administrative Hearings to participate in today's hearings to discuss our role in the administrative adjudication process for individuals appealing a decision made by a Department of Consumer Affairs regulatory agency regarding their professional license or license application. I'll provide a brief overview of an OAH hearing from start to finish, an estimate of how long it typically takes for each step in the process, our current staffing conditions, and highlights from our 2014 caseload report we submitted last year. By way of background, OAH was created by the legislature in 1945 as part of the Administrative Procedures Act, meaning it's the first central panel created in the United States that sits independently from the agencies that hire us to conduct the administrative hearings. OAH is a fully reimbursable agency, and we are housed within the Department of General Services. We are comprised of two divisions. The General Jurisdiction Division hears cases from the Department of Consumer Affairs. We also have a Special Education Division, which exclusively hears cases under the Individuals with Disabilities Education Act, and we do that with a contract with the Department of Education. Our involvement in the DCA license discipline process is initiated once a request to set form is received from either the regulatory agency or the AG's office after the licensee or license applicant requests a hearing to challenge the proposed action by the board. Once this form is received, OAH opens the case in our case management system, and assuming everything in the request is accurate and it's been fully completed, unless the agency requests a trial setting conference, it takes about 2 days, 2 to 5 days for us to set a case for hearing initially. The setting of that initial hearing date depends on a number of factors, including the anticipated length of that hearing, the availability of the parties, their attorneys, their witnesses, and sometimes it depends on the office location in the state where that case is going to be heard. Short cause cases, which can be heard in less than a day, are set quicker than the longer cause days, which generally take 4 days or more to hear. Unless the parties seek and are granted a continuance, the hearing will take place on the date it was set. OAH guarantees that that date we give the parties, we will have a judge available to hear that case for them. However, by law, the parties are entitled to a continuance if they establish good cause. If continuance is granted, the hearing date will be postponed, but it has to be a date that the parties are all available. Hearings themselves can take a few hours or a few weeks, but average 1.2 days for last fiscal year for our office hearing DCA cases. The length of the hearing can depend on a variety of factors such as the novelty of the legal issues raised, the number of expert or other witnesses to be called, the nature of the testimony and of the other evidence to be presented, the number of attorneys involved, of course, and the need for language interpreters, which is often the case. But once the hearing is completed and the case is submitted for decision, our ALJs have 30 days to issue a proposed decision in most DCA cases. Last fiscal year's average for this step in the process was only 25 days to the issuance of a decision. Once we issue our proposed decision, it's up to the regulatory agency to take appropriate action, and our involvement is typically over at that point. Now, as you probably know, beginning on September of last year and every year until 2019, OAH is required to produce a report on caseload and hearing timeframes to the Department of Finance, the Joint Legislative Budget Committee, and this was imposed pursuant to supplemental budget language enacted in the 2014-2015 budget package. This report was provided to the committee, and we have brought copies today to share with committee members. This data includes hearings for disciplinary actions against licensees, as well as hearings on license denials. It reports information on cases and timelines for calendaring, hearings, and decisions by each board under DCA's jurisdiction. In fiscal year 2013-2014, DCA filed 4,303 cases with OAH. Of those, over 1,800 went to hearing. And of the cases that went to hearing, 1,300 and around 30 resulted in an administrative decision by one of our judges. All other cases resolved without a hearing or decision. From start to finish, it took an average of 204 days, or about 7 months, from the time a case was filed with OAH until a proposed decision issued for DCA cases. Now, this statistic does not include cases that were resolved prior to hearing. In terms of OAH, overall, we have a staff of 10 presiding judges, 86 administrative law judges, and 47 support staff. We also utilize pro tem judges on a contract basis when necessary to ensure our cases move through in a timely manner. Our presiding judges supervise teams of ALJs and manager the hearing calendars for each office, but they rarely hear cases. The General Jurisdiction Division, which is the division hearing DCA cases, consists of 6 presiding ALJs, 55 ALJs, and 35 support staff across offices in San Diego, Los Angeles, Oakland, and Sacramento. In the 2014-2015 budget, 14 additional ALJ positions were approved for OAH. However, the purpose of adding these positions was to reduce our use of pro tem judges while still handling our very heavy caseload. 10 of these 14 judges were assigned positions in the General Jurisdiction Division, which can help out with DCA cases. The 10 positions were filled between September and December of last year, and it takes about 3 months to fully train up an ALJ until they're ready to hear a full-time calendar of cases. The addition of permanent staff should allow us to meet our workload increases, reduce case setting timeframes, and improve customer service in general. As of today, it's too early to tell what the impact of transitioning from using experienced, trained pro tems to training up a group of new ALJs will be, but I'm confident we're moving in the right direction with this move. We'll have a better idea of how the addition of these permanent ALJs will impact us in the next coming fiscal year. The committee had asked if OAH has any performance standards for the timeframes in which it handles cases. Recognizing OAH's primary role and responsibility to ensure due process is provided to the parties, we strive to be efficient in those areas over which we have control, such as entering cases into our case management system, setting an initial hearing date that the parties can agree upon, conducting efficient hearings, and issuing timely proposed decisions. We're currently developing key performance indicators for the processing of our cases, such as the opening of the cases, the setting of that initial date, and the issuance of the proposed decision back to the board after the case is submitted. We fully expect to improve case setting times over the next year, as we now have been granted permission from CalHR to utilize a higher classification for our calendaring staff, which is very important to us. Previously, our calendaring staff could not promote into a higher classification without assuming new duties unrelated to calendaring. With this new promotional opportunity, we hope to retain our trained and experienced calendaring staff instead of having them leave for better employment opportunities elsewhere. We're confident this will help improve calendaring timelines as well. I've brought with me today my Deputy Director and the Divisional Presiding Judge of the General Jurisdiction Division. If you have any questions, we'd be happy to.
Very good. Thank you very much. Yes, Senator Wojciechowski.
I don't know anything about administrative law hearings, but I was wondering, prior to that first hearing date, do you have like a pre-hearing conference or a pre-hearing conference statement so you can sort of narrow the discussion that you may have on the hearing date? Is there any procedure like that that you would have in civil practice or criminal practice?
I believe the parties can request something similar to that, yes.
I'm just wondering because we're geared towards matrices and you know, not so much on due process. So we're trying to determine, is there a procedure that we can borrow from other civil or criminal courts that sort of tighten up the 204 days, that because it seems like in civil cases and criminal cases, you get the judge to sit down with the parties and say, okay, what's this case about? What's the conflict here? How can we come to resolution? Sometimes that has proven to be beneficial.
It's my understanding that the procedure in these cases, it's up to the parties to request that at the beginning and that we can set that for them. But there's no automatic requirement in the Administrative Procedures Act that I'm aware of that mandates that right out of the gate.
And no statements that are filed before that first hearing? Or is it just? Because I come from the bankruptcy world, so we have, before we have a hearing, we have 2 weeks before, we have to mandatory conference with the other side and mandatory statement that we have to produce to the courts. So this sort of helps you narrow what your day in court's going to look like, rather than we'll hide the ball and go in there and the guns a-blazing in the traditional model.
Right. This is our Deputy Director, Melissa Crowell. She has much more experience in the actual handling of the cases than I do.
You push the red button, please. Thank you.
Good afternoon, sorry.
Yeah, sorry about that.
So we were talking about the complexity of cases varying, and what we view as a 4-day case or more, we actually automatically set that for a pre-hearing conference in every case. If the attorneys request a pre-hearing conference on a case that's shorter than that, we would set it, or if the presiding judge feels that this is a case that warrants it, we would set it. And one of the things we often do is we have an early status conference with the presiding judge, and they do exactly that. They talk about how many days do you need for hearing? Can the issues be narrowed? So we do get involved, not in every case, but on a fair number of them.
Thank you, Senator Wojciechowski. And thank you for preparing this report and the statistics kind of a year earlier than mandated. In it, are there any plans to expand some of the measures that you've used in here?
In terms of expanding what we're reporting back on?
Reporting back on, yes.
I haven't had any discussions on that.
And have you had the opportunity to compare your data with that of DCA boards to see if there's consistency in the reporting or the data that you're reporting and what they have?
We haven't yet. I'm waiting to get a nasty email from them telling me I'm wrong, but I haven't received that yet. But no, it's something I hope to discuss. I've been on the job assuming this duty since the end of January, so I'm new to the process and new to the table in which everybody's
Oh, you won't get a nasty email from them, I don't think.
But I'm happy
They
to
don't send
discuss
them, but-
those.
Very good. Seeing no further questions on this, I mean, I think the goal, obviously, from what you've heard and what we've read in those report backs, is some timeliness and the ability to get justice in a timely manner. So I would hope that we could come together a little bit to see, and we'll be asking that question next year, and if not before, to make sure that we can cut that time down and give some reasonable, I mean, we have some reasonable expectations that we can see justice in a timely manner. So hopefully you can work on that and see if it's possible to do so. Thank you very much for coming today. Appreciate it. Now we will move to item number 2, review of the Board of Registered Nursing. So please come forward. I know, but I definitely got that. Right, well, that's why I called her on it. She'd complain about that before. Sarah, how are you?